The conviction that I'd like to talk to you about in this video will probably shock you and maybe even cause you to lose faith in the criminal justice system in England and Wales. But before you go too far down that road, there is some good news if that's the case, because this conviction was appealed and the appeal was successful. The conviction overturned and quashed. But not before this defendant had to go through the entire criminal process, get convicted, be punished, and then have to go through the whole process of appeal. I'll explain how those appeals work in just a moment. So just generally, and before we get into that, I'm going to explain that you've got two routes for being prosecuted and having your trial heard. Broadly speaking, in England and Wales, we've got different offences which are either more or less serious. Some of them fall in between and they're known as either way. An either way offence can be heard either in the Magistrates' Court or in the Crown Court, and the magistrates will hear your case and not a jury, and obviously once making a finding of fact and a verdict against you, they will then hand out a punishment. Whereas in the Crown Court, obviously you'll be familiar with the jury, the finder of fact gives you a verdict, and then it's the judge that decides what sentence you get. If you opt for the Magistrates' Court, it's normally quicker, it's less visible, it attracts less media and publicity, but there is a much higher conviction rate within the Magistrates' Court, although they are limited to sentences of no more than 12 months for one given offence. The Crown Court has higher sentencing powers, takes longer, is usually much more visible in the media, but of course the prosecutor has to convince a jury, all 12 members ideally, rather than a single bench of magistrates. If you go to the Magistrates' Court first and you're convicted, you do have an automatic right of appeal to the Crown Court, and that is what happened in this situation. It appears in this particular case that it was a district judge that heard the case in the Magistrates' Court, but obviously still not a jury, and still statistically more likely to be convicted in the Magistrates' Court, whether it's by magistrates or a district judge, than in the Crown Court, because of course the prosecutor has to convince the jury rather than a single judge or a bench of magistrates. So let me tell you what happened, and you'll probably be quite surprised and probably think to yourself, this should never have been prosecuted in the first place. So yes, you can be prosecuted for thought crimes and things that you post on social media in England and Wales, and this case is one such proof. So welcome back, but if you're new to my channel, I'm a barrister who helps you to understand law, and I'd be really grateful if you smash that like button and the subscribe button, because it helps my channel grow, reach a wider audience, and help more people to understand law. So this case that I'm talking about here, Chelsea Russell, who was 19 years old at the time, from Liverpool, posted the lyrics from Snapdog's I'm Trippin' song on her Instagram account. Now, she created this post in tribute to a boy who died in a road crash, as was told the court. However, she was ultimately convicted and given a community order, as it was said to be a hate crime, because the words in those lyrics were of a particular nature, which I'm not going to repeat because I don't want this video to be flagged. Reading from the BBC article, which I will link in the description below, she was charged after Merseyside police were anonymously sent a screenshot of the update on her Instagram post. After which, of course, she was prosecuted and then tried at the Sefton Magistrates' Court in the Liverpool Justice Centre and convicted. So all of which proves that if certain words are considered to be offensive, somebody might anonymously report those to the police. The police may then arrest you, interview you, you may even get charged and prosecuted and convicted, as was Chelsea in this story, even though the words in that song are obviously still audible and you can still hear them on the song right here on YouTube. In fact, if you search that song, you'll find the official version of that video with exactly those lyrics that were complained of in this case, because I checked. The first thing I did when I read about this particular conviction was to look for those lyrics and see where you could find them online, and sure enough, you can find them practically everywhere. And of course, you can find the original song virtually everywhere. So whilst they might be considered by some to be offensive, that doesn't stop the song from being available. Although on this particular occasion, because Chelsea had posted those lyrics to her Instagram account, somebody screenshotted it and then she got convicted, saying that those particular words were grossly offensive. As part of the punishment, she was given an 8-week community order, placed on an 8-week curfew between the hours of 8 p.m. and 8 a.m, also ordered to wear an electronic tag on her ankle during that time, and also ordered to pay £500 toward costs and an £85 victim surcharge. However, moving on to the appeal in the Crown Court, Mr. Beardmore, defending, made an application of no case to answer. What this means is once the prosecution have closed their case at the halfway point, so this is sometimes known as a halfway submission, defence counsel can make an application of no case to answer, meaning that the prosecution have failed to make out a case where a defendant could rightly be convicted. Or in this case, which was an appeal at the Crown Court, which was heard by way of a rehearing or a retrial, but not with a jury. This time in the Crown Court, as an appeal, it will be one single Crown Court judge and 2 magistrates that hear the appeal for this case. Mr. Beardmore observed, as I've observed in this video, that this video of this I'm Trippin' could be watched on YouTube and the lyrics read online and the track listened to on iTunes and many other platforms. He said that none of these other publishers had been arrested, yet now it was tenuously suggested that pasting these lyrics on Instagram was illegal. He goes on, "It's a ridiculous state of affairs and quite staggering that in a liberal democracy we're taking up court time talking about this particular type of activity. It may well be understandable, perhaps if we were in a totalitarian state, but we're not. We're in the UK." Mr. Beardmore said that prosecutors had to prove that Russell intended these words to be grossly offensive, and went on to say that it might be the case that some find this music offensive, but that is not sufficient for the offence to be made out. The judge, sitting with 2 magistrates, said that it was an unpleasant term, which I agree with, by the way, but one commonly used in hip-hop music and culture. The judge hearing the appeal, Recorder O'Brien, said when she was interviewed, she simply said she had no intention of being, as she put it, horrible. And it's our view that there was no such intent in this case that would be required for a conviction. He went on to say that it's our view that the words which were set out on the Instagram account by Chelsea Russell were thoughtless, offensive and unpleasant. But it's our view, applying the legal test, that they were not grossly offensive and therefore this appeal is successful. Meaning the conviction is quashed, she no longer has a criminal record, but not without having to go through that whole process of going to court, being convicted, at least starting that punishment process, all the while waiting for her appeal to be heard, only for it to get to court and her defence lawyer to say that this was a ridiculous state of affairs, and ultimately the judge agreeing. Not to say that the judge approved of the words, obviously not, but that she didn't intend any gross offence to anyone else simply by pasting those words on her Instagram account, and therefore the offence was not made out. However, this is not the end of the matter, because it might surprise you yet further to hear that many thousands of prosecutions like this happen each and every year across England and Wales. Of course, in many of those cases, it is quite right that those cases are prosecuted because many of them are derived from racial hatred or other forms of hatred that quite rightly should and are prosecuted. But I do wonder if there were a very detailed and granular level investigation as to how many of those prosecutions are cases similar to this that are taking up court time and many thousands of pounds and putting so many people through such misery of going through, being prosecuted, being convicted, having to start their punishment whilst waiting for the appeal, only for it all to be overturned on appeal at the Crown Court. Nonetheless, the moral of this story is, please be very careful and thoughtful about what you paste on social media. If you do paste certain things, qualify what you say even that you don't mean any offence by it. Although that will ultimately be a self-serving statement, as it's known in law, if ever you were prosecuted. But at the very least, if you were prosecuted and you get to the police station and you said, which I assume for most people would be the case, that you didn't intend any gross offence to anyone else, you simply reposted lyrics that are freely available on the internet, and indeed the video is still freely available on the internet and on YouTube, no less. Now, YouTube is well known for taking down hate speech and all of these kind of things, but certain things like this, YouTube seems to be happy with, because they are just lyrics after all. It's really the intent behind the words and the usage of those words and the intent beholden within the person who's putting those words out that might ultimately get you convicted and get that conviction upheld on appeal. So as I always say, please be careful what you post. Make sure if you do post things, you are qualifying what you are saying and that you are not intending any gross offence. Because in recent years, it really does seem that lots of people are prosecuted and convicted for things that ultimately get thrown out on appeal to the Crown Court. So as always, please leave me your thoughts and comments in the box below. Qualify them if necessary. Please make sure you smash the like button and subscribe. And as always, thank you for watching.